Well, good afternoon, everyone. This is Mo at the chamber, and it's 2 minutes after 2 o'clock, and we're going to go ahead and get started. I want to thank you for your participation. I'd like to thank Kyle Krasa for being with us and his willing to present the information. Everybody is on self-muted by Kyle. In terms of questions, you would go to the chat room, which is down on the bottom center. You would click on the chat room and type in any question that you would like. At the end of the presentation, which should take approximately 45 minutes, Kyle will attempt and try his best to answer some of the questions. If your question hasn't been answered, we will log the question and forward them on to Kyle, and Kyle can answer them, and then we will submit them. With that in mind, Kyle, it's all yours.
Okay, well, thank you very much, Mo, and the PG Chamber for having this great idea to present important information about Prop 19 on this Zoom meeting. As many of you know, Prop 19 was a ballot measure on the ballot on November 3rd, and it passed by 51% of the vote. And it, among many things, one of the things it does is it substantially limits the ability of a parent to pass your Prop 13 property tax on to a child. So Prop 19 does a few other things. I'm going to focus on that aspect of it because that directly relates to estate planning. There is a window of time before Prop 19 becomes effective. You'll hear this date over and over again throughout the presentation. It's effective on February 16th, 2021. So we do have some time under the current rules before Prop 19 comes into effect. Let me see if I can, there we go, move the screen. I'll just give you quickly some background. Most of you know me. I grew up here on the Monterey Peninsula. I went to Forest Grove and PG Middle School and Stevenson, and still live in my grandparents' house that they purchased in the late 1950s. Other than going to college in Vermont and law school at UC Davis, I've lived on the Monterey Peninsula my entire life. And I'm a certified legal specialist in estate planning, trust, and probate law. My office is in Pacific Grove on Forest Avenue. I'll just mention my website where there's a lot of information about estate planning, videos about estate planning, and so on. So I am an attorney. We have some disclaimers always. This is not legal advice. This is just general information. The law is complex, it's nuanced, and it applies differently for different people. And the challenge, as in most cases, and especially with Prop 19, there is no one-size-fits-all solution. And so it's going to be different for everybody. And so it's really important that you do not act on any of the information I'm giving you without first seeking the counsel of an attorney. Hopefully this will give you some general idea so you can decide whether you think it makes sense to explore whether you want to take action before Prop 19 comes into effect. But it's so nuanced and there's so many details, and your particular situation might be different. And I also can't go over all the details of law in a short presentation like this. The other thing that's important to understand is that we don't have official guidance yet on how to interpret Prop 19. Prop 19 did not come from the state. It was a ballot measure. So the Board of Equalization, which is the organization, the government agency that needs to interpret laws in this case and issue regulations and interpretations, they're trying to figure it out themselves. And we might not have that guidance for a long time. So there's certain things where we know what the proposition says. How will that be interpreted? We don't necessarily know, and we might not know for a long time. And just a reminder as well, this discussion only applies to California real property. So if you might have vacation property or rental property in another state, totally different rules for another state. We're only going to talk about California property. I want to go over the agenda. First, I'm going to give you a brief overview of Prop 13 to understand how Prop 13 works. You can't understand Prop 19 unless you understand how Prop 13 works. I'm going to talk about what the current rules are for parent-child transfers of real property that are in effect until February 16th, 2021. Then I'm going to talk about how Prop 19 changes those rules, and so what the rules will be on or after February 16th, 2021. And then we'll talk about planning options that you can do prior to February 16th, 2021, prior to Prop 19 becoming effective, and then planning options, what are we left with after February 16th, 2021. And as I mentioned, you go ahead and use the chat function to ask questions as we go. I'm not going to look at them until the very end, but I will stick around as long as possible and try and answer as many of the questions as I can. So to give you some background about Prop 13, most of you are probably familiar about how Prop 13 works. Basically, property tax in California is based on the assessed value of the property and not the fair market value. So assessed value in general, and this is just in general terms, it's generally the price that you paid for the property, subject to certain adjustments. So for example, if you did some new construction since you purchased it, there'd be a little adjustment there. Also, that assessed value can increase up to a cap of 2% per year, but real estate appreciates at a faster clip, especially in California, 4 to 6% per year or even more. So what happens is over time, the longer that you hold on to real property in California, a gap develops between the assessed value, the value for purposes of calculating your property tax, and the fair market value. And so Prop 13 is alive and well right now. If you buy a house today, you are still covered under Prop 13. You don't feel like it, but you are, because if you hang on to that property, even though you're buying it today, you're going to pay the market rate. You're going to pay property taxes based on the current fair market value. If you hold on to that property for 20 or 30 years, 30 years from now, people are going to say, wow, you're paying really low property tax. So it favors people who hold on to their property for a long time. It disfavors people who don't hold on to their property for a long period of time. So for example, this is a complete fiction here, but let's just say this hypothetical person, Robert, buys his house in 1990, and the assessed value is $400,000. That's based on what he paid for it, subject to a few adjustments, minor adjustments per year. The fair market value today is $1.2 million. Robert's property taxes are based on the $400,000, not the $1.2 million. So the property taxes are roughly 1% of the assessed value. There are some little adjustments there, and some add-ons, but I went to law school, so I didn't have to do math, so I'm gonna make the math really simple. We're just gonna assume property tax is 1%. We'll know it's a little bit of adjustment there. But Robert's property taxes are $4,000 a year instead of $12,000 a year because of the fact that he's held on to the property for a long time. Doesn't matter how much it increases in value. The general rule is that whenever there's a change in ownership, there's going to be a property tax reassessment to the value, to the fair market value on the date of the transfer. So if Robert transfers his house to his brother, when the house is worth $1.2 million and his brother acquires it, then his brother's new property tax, new assessed value is going to be $1.2 million, and his property taxes are going to be $12,000. So they're going to jump from $4,000 to $12,000. This is true if Robert gifts the property to his brother. This is true if Robert sells the property to his brother. So we don't care in the property tax context and the assessed value context whether or not it's a sale or a gift. It's just whether or not it's a transfer. Now, for many years, 35 plus years, there's been a major exception to this general rule that whenever there's a change in ownership, there is a property tax reassessment to the fair market value on the date of the transfer. And that is the parent-child. That is for parent-child transfers. It applies to certain transfers between parents and children. And I say that it's downstream and upstream. And what I mean by that is that it could be a transfer from a parent to a child, but it can also be a transfer from a child to a parent. So it works both ways. The transferor could be the parent, and the transferee could be the child, or it could be the reverse. So downstream from a parent to a child, and upstream from a child to a parent. Now, for purposes of my discussion, I'm going to assume that the transferor is always the parent and the transferee is always the child. It makes it easier when we talk about transfers from parents and children than using the language transferor and transferee. But just know it can work both ways, and Prop 19 affects these rules as well. The parent-child exclusion under current law applies to both residential and commercial property. So it could be your house, could be your rental property, could be your office building. It applies to property that is owned either by you as an individual or property that is owned through a trust The parent-child exclusion rules do not and have never applied to property that is owned by an entity, like an LLC or a limited partnership or a corporation. There are different rules there, and we're going to talk about that at the end of the presentation because Prop 19 does not affect those rules. The parent-child exclusion rules are generally more favorable, but after February 16th, all we have left is the entity rules, and there could be some opportunity there. And we'll talk about that at the end. So keep that in mind. This is only if you own the property either as an individual or through a trust. It's also important to understand that these parent-child rules, they can also apply in very limited circumstances for transfers between grandparents and grandchildren. But there are a lot of restrictions on the grandparent-grandchild transfer rules. For example, the grandparent-grandchild rules are one way only from the grandparent to the grandchild, not the reverse. There are also other restrictions. The middle generation must be deceased. What does that mean? If my dad wants to transfer property to my son, there's going to be a reassessment if I'm still alive. If my dad wants to transfer property to my son and I'm deceased, but my wife is still alive and she hasn't remarried, then there's still going to be a reassessment. So it's very limited. And there are other limitations as well. And I won't get into that, but just know that Prop 19 affects all of these kinds of transfers. So again, for purposes of this discussion, I'm going to assume that the parent is always the transferor and the child is always the transferee. So within this exception, under current rules, parent-child transfers, when it comes to the parent's principal residence, the parent can transfer that to a child, and it doesn't matter what the value of that property is. I want to back up 1 second. Child is very liberally defined. So it can be your biological child, an adopted child, as long as they were adopted before they turned 18. It can be a stepchild. It can be a son-in-law or a daughter-in-law. So it is very broad. Okay, so when it comes to the parent's principal residence, they can transfer under current rules their principal residence to their child without any reassessment, regardless of its value. So the principal residence could be worth $1 gazillion, and you're going to keep that Prop 13 as long as it's going to a child. The child also may use that transferred residence for any purpose. So if the child wants to move into it and use it as their residence, no problem. If the child wants to use it as a vacation home, no problem. Rental, investment, whatever the case. And remember, this is a transfer. It doesn't matter if it's a sale or a gift, same rule applies. In addition, under current rules, parents also can transfer a certain amount of other real property that is other than their principal residence to their children, subject to one basic limitation. And that is they have $1 million cumulatively of assessed value that they can transfer. So when we take a look at any property that's not the principal residence, a vacation home, a rental, commercial property, the parent can transfer that property to a child up to $1 million worth of assessed value. And that $1 million limit is actually very high. It's not fair market value, it's assessed value. So you might have a piece of property that has a fair market value of $2 million, but only $500,000 assessed value, you can transfer that. So let's take a look at this, kind of put this in context here. So Robert's house, we said, has an assessed value of $400,000 because he bought it back in 1990. It's worth $1.2 million today. He transfers it to his daughter Sally, who lives out of state. She never uses it. He never uses his transferred property as her principal residence. Under current rules, she keeps Robert's assessed value. She continues to pay approximately $4,000 a year in property taxes. Robert also has a vacation house and a commercial property. And the vacation house has an assessed value of $400,000. We don't care what the fair market value is. And the commercial property has an assessed value of $500,000. So he's transferring two additional pieces of property. We add those assessed values together. That's under $1 million. That's under the cap. And Sally will be able to keep the property tax base for those properties as well. So, so in this scenario, Robert can transfer 3 properties to Sally, his principal residence, and those 2 other properties, and we're well within the limits, and it's fine. Now, if he exceeds the $1 million cap of assessed value, then there will be a reassessment for that amount over. And this is also true regardless of how Sally chooses to use any of those properties. She doesn't have to, no limitations on how she uses it. Okay, so how does Prop 19 change things? So number one, only the parent's principal residence is going to have a shot at keeping the Prop 13 property tax. In some cases, the family farm, I'm not going to get into that today. We're just going to focus on residence and commercial property. So there is going to be a full reassessment on other real property, the vacation house, the rental property, the commercial property, no matter what. After February, on or after February 16th, 2021, for any transfers that happen on or after, only the principal residence has a shot at keeping the Prop 13. Everything else is going to get reassessed to the fair market value as of the date of the transfer. But that's not the end of the story. Just because it's the parent's principal residence or the transferor's principal residence is not the end of the story. There are two more limitations on being able to keep the Prop 13 for the child. The second one is that the child who is receiving the property must use it as the child's principal residence within a year of the transfer. Now, for how long do they have to use it? We don't know. We don't have any guidance. Can they use it for 6 months and then move out? Or do they have to stay there? Even if they stay there 20 years and move out, is it going to be reassessed when they move out? We don't have any guidance. We do know that if the child lives out of state, that's probably not going to happen. If the child lives in the same town, then that's easier to happen. That might not be the plans. They might not want to move into the house, but at least they might be able to do it. So that's a big limitation. If you have 3 children and only one wants to take it, that can create some complications. There might be some planning around it. Well, again, we don't know the details of some of these rules yet and how that would apply in different situations. But even if we cover those first 2 hurdles, so it's the property being transferred, is the parent's principal residence. The child says, oh yeah, I'm going to move into it within a year of the transfer, no problem. We have one more hurdle, and that is a value limitation. So the child will only get to keep the parent's property tax base if the property is worth up to $1 million plus the assessed value. So if there has been a big increase, a big change, a big gap between the assessed value and the fair market value, there's likely going to be a partial reassessment even in this situation as well. So let's, again, put this into some context here. And this is post Prop 19 era, post, on or after February 16th, 2021. Robert transfers his principal residence to Sally. Sally doesn't use it as her principal residence, fully reassessed. That's it, end of story. Sally, same facts, only Sally is going to use it as her principal residence. Okay, now we've cleared the first 2 hurdles. It's the residence of the parent. It's going to be used as a residence of the child upon transfer. Now we look at the value limitation. So I said that the assessed value is $400,000. So the limit would be 1.4 million because we take 1 million and we add it to the assessed value of 400,000. And I said the fair market value is 1.2. She gets to keep the entire Prop 13. If the fair market value is over 1.4, there's going to be a partial reassessment for the amount over. So, and then for Robert's other real property, his vacation house, his commercial property, that's going to be fully reassessed in that case. So the Prop 19 really does severely limit and restrict the parent-child exclusion. And a lot of people have estate plans that were based on these rules, thinking that the children were going to be able to keep the property tax, and that changes after February 21st. So what are some things that we can do prior to February 21st? Between now and then, we are under the current rules. So if you make a lifetime gift to your child of your residence or of other property, we are still under the current rules. We don't have these limitations, these new limitations, until February 21st. So what you might consider doing is gifting some property to your children under the current rules, or gifting percentages of your property to kind of mitigate the amount of reassessment that's going to happen once you pass away. There are issues though with that you have to be aware. It's not just a no-brainer done deal. You have to really carefully consider some issues, and I'm going to go over some of the more common issues that you need to think about. So number one, generally speaking, it is from a capital gains standpoint. When in capital gains tax at a very rudimentary level, it's tax on the difference between your purchase price and your sales price, right? So Robert buys the house for $400,000. He sells it for $1.2 million. He might have capital gains tax on that $800,000 difference. Now, if it's his personal residence, there's a certain amount of exclusion. There's some other things. If he's put money into the house, we call it his basis, his starting point for determining gain is different. But from an income tax perspective, generally speaking, you pay capital gains tax on the difference between the purchase price, subject to some adjustments, and the sales price. And if you transfer property during life to your children, they're going to inherit your basis. If they ever sell that property, they're going to have to recognize gain going all the way back to what your basis is. If you wait until you die before you transfer property, the basis will get adjusted to the fair market value on your date of death. It's often referred to as a step up in basis, assuming the property value is going to go up. And then if your children sell it 10 years after you die, they're only going to have to recognize gain going back to what it was worth when you died, not your original basis. So making a lifetime gift often will involve losing that step up in basis for your children. So if you know that your children are likely going to sell the property after they inherit it, well, then you probably don't want to gift it away during life, because you're not going to worry about the property tax, you're not going to hang on to it for too long, and you want them to be able to mitigate and minimize the capital gains tax. If you know for sure that they are never going to sell this property, they're going to keep it forever, they will never sell it, then it makes sense to transfer it. Most people are not in one of those two camps. Most families are, we don't know. We could go either way. And so it's really a pick your poison situation. So you have to be aware of that. Secondly, you're losing control when you transfer the property to the child. So that's a big deal. Many people who might be considering making transfers before Prop 19 becomes effective would not have considered doing that if the 49% went the other way. And so, do we fold ourselves into a pretzel just because of the tax rules? Are we going to let the taxes change our behavior here? It's going to be totally in the control of the child that you transferred it to, and that could be an issue. There might be ways to try to retain some degree of control, but you have to be careful because the Board of Equalization might not consider that a transfer. And so you want it to be considered a transfer before February 16th to be under the old rules. But if you retain too much control, it might not be considered a transfer. If it's a rental property, are you prepared to lose that rental income? I mean, if the title now belongs to the child, that rental income belongs to the child. The child could share it with you, but you get into gift tax issues if they transfer the income back to you. I think one of the biggest issues is changed circumstances. What if you want to move? One of the features of Prop 19, one of the other sides of it, was it allowed you, if you're 55 or older, to take your Prop 13 property tax base and move it to another property anywhere within the state. And you could do that 3 times. Well, if you've transferred your property to your children, that's not going to work anymore. So you're going to forego a major advantage of Prop 19 by transferring the property to your child early. I think there are very special mortgages, and it gets really sticky if we're talking about transferring property that have mortgages. There is a rule, a federal rule, Garden St. Germain Act, that does say under certain circumstances, parents can transfer property to their children and the loan won't be affected. They won't call the loan, but not in every circumstance. And regardless, if there's a mortgage on the property, I would be nervous about it. I talk to the lender and make sure that the lender's not going to call the loan in that situation. So you definitely want to be careful about that. And to the extent that it's possible to contact the lender and get written permission to do it and say, look, we're not going to call the loan, that would be good. But anytime I see a client that's thinking about making a lifetime gift with a mortgage, I'm going to be really nervous about that. More issues. If you transfer your residence to your child, do you have to pay rent to your child? Maybe, you know, you probably do. There is a court case going back, I think in the 50s, where, you know, dad transferred on title. He deeded his house to his kids, but he still lived there and he never paid rent. And actually he paid the property tax and he paid, you know, all the expenses of it. And the IRS, from an estate and gift tax perspective, said you didn't really transfer it. If you want to make it a completed gift and say, no, he really did transfer it, you've got to start paying fair market rent to your children for the house that you already live in. Going back to the mortgage issue, one other point I want to make on the mortgage issue: even if the lender is totally fine and gives you written permission to do it, and you're all good, it creates all kinds, I think, of family dynamics issues, right? So the children would be legally obligated to pay the mortgage because now they own the property. Would they? Or would the parents keep doing it? If the parents keep doing it, are they making gifts to their children by paying the mortgage? Probably. Family dynamics too. You know, does the parent feel like, I just gave you a house, you should now start paying the mortgage? And the child says, well, we're treating it as your house. It's just on paper. You keep paying the mortgage. I mean, it could get really ugly. So you need to think about those things. All the expenses too. I mean, whether there's a mortgage or not, who pays the property tax? Who pays the insurance? Legally, the owner should do that. If the parents do it, that's gifting, and that can get into some gift tax issues. Family dynamics, you can get into arguments over who's supposed to pay these kinds of things. So you don't have this neat separation of what's yours is yours and what's mine is mine. There are estate and gift tax issues. If you do transfer property, you are going to have to get it appraised and file a gift tax return, and it's going to use up some of your estate and gift tax exclusion. That's a discussion for another time, but you have to be aware of that. You don't have to get the appraisal and file the gift tax return before February 16th, but you will, you'll have to make the transfer before then, and then you will have to do that within the year. There are other issues too. So you transferred your property to your child. Well, what if your child gets sued? You know, they're driving around now, driving around and they get in a car accident and they get sued, and the plaintiff says, oh, I want that house. Now you're without a house because of liability of your child. What if the child gets divorced and the divorcing spouse says, okay, I'm going to take part of that property as mine, and you're still trying to live there? What if the child predeceases you? And we've got a couple of issues there. One, where is the property going then? So you might say, I'm going to give it to this child. We have this understanding. We are best friends. The child, I know legally the child could kick me out, but they're not going to. Everything's going to be great. We're going to get along with how we're going to share the expenses and how we're going to operate and everything else. And then the child predeceases the parent. And now where it's going, maybe now the property is going to somebody that doesn't have that same viewpoint and that same relationship. Also, if the child dies, guess what? That's another change in ownership, and most likely it's going to result in a reassessment. So here, you had this property, you're under Prop 13, you know that your property taxes aren't going to change for your lifetime. The only reason why you're transferring this to your child during life is you don't want the child to be reassessed, but you were never in danger of being reassessed, so you transfer it. Then the child predeceases you, and now you get reassessed while you're still living there. So that could be a problem for sure. As a result, it's best never just, if you're going to make a transfer during your lifetime, you really should not just take a shortcut and just transfer, sign a quitclaim deed and be done with it. Really, at a minimum, should establish a separate, irrevocable gifting trust that's different than your living trust. It's a different type of trust that would address many of these issues. That gifting trust would have a degree of asset protection. So if your child got sued, it would be less likely that the child's plaintiff could go after the property. There could be divorce protection built in. You could make it clear or clearer that the property belongs, the gift is for the child alone and not for the child's spouse. Still could be sticky if you use community, if the child and their spouse uses community assets to pay expenses, but still having a trust would create a better bright line division between separate and community property than just an outright gift to the children. If the child predeceases the parent with an irrevocable gifting trust, you could control who that contingent beneficiary is, maybe make it another child, maybe make it somebody else that you're comfortable with. There still might be a reassessment at that point, but at least you can control who that person is, and maybe they would you'll be comfortable with that person being in charge. There might be a way with drafting the right way to try to save that step up in basis, although I think there is a lot of risk there. But you could put a trust together and include some flexibility where maybe if we understand the law a little bit better, maybe we can look at that a little bit more. But there are certain a trust won't solve all the problems, but it's still better than just outright. I don't think I would be comfortable being involved in just an outright transfer to children. I think I would insist on having some sort of irrevocable trust drafted to transfer the property through that trust to have at least some protections. Occupancy, you can't retain a lifetime right of occupancy and transfer the property. That won't be considered a transfer by the BOE. They'll say, well, you've retained this right to live there, so you haven't transferred that yet. What you could possibly do is transfer the property, and then later the kids might grant you the right to stay there for a term of years. Has to be a term of less than 35 years. That might work. So if you want to have some assurance that you're not going to get kicked out, but you have to be careful because you can't really have a prearranged plan here. It has to be you transfer to the kids, and then the kid says, okay, I've decided I'm going to give you this right of occupancy for a term of years. That might work. So there are ways that we could sort of address some of these issues, but the bottom line is that you are going to give up substantial control over the property if you make a lifetime gift. So often, the drawbacks of making a transfer and beating Prop 19 and doing it before February 16th will outweigh the interest in trying to preserve the Prop 13 assessed value. But for the right client in the right circumstances, making transfers prior to February 16th, 2021 could be a prudent move. It's different for everybody. In one day earlier this week, I think it was on Tuesday, I had one call with a client early in the afternoon, and we went over, the assessed value and the fair market value and the children's situation and her different properties, and we concluded just don't do anything. Let it be reassessed. It's going to be too complicated to try and make any lifetime transfer. An hour later, I had a call with another client. It made perfect sense to transfer it before February 21st, February 16th, 2021. So the main question you have to ask is that question that starred with 3 stars. Are you willing to give up substantial control of your real property now? That's what you've got to ask yourself. And if the answer is no, that's good to know. Then you don't need to waste your time or your money or wait, spend attorney time in doing that. Attorneys are going to be very busy with people. If you say, I'm open to it, or yes, I'm willing to do that, then you can explore it further. But that's the main question you have to ask yourself. Make sure you pretend, the deadline is February 16th. Pretend that the deadline is February 1st. I think I'll probably have a policy. I'm not going to entertain this for any new client beyond February 1st, because it's just we don't have a whole lot of time to get things done. Under property law, the transfer, now first of all, death, if you die, the date of the transfer is the date of death. So even if somebody dies January 1st, but they don't distribute the asset out of the trust until March or April or May or June, the transfer happened January 1st. When you, under property law, when you sign the deed, that's the date of the transfer, except the BOE has this presumption that the date of the transfer is the date the document is recorded. So, we would rather you record the deed as best you can before February 16th, which I think is a holiday. President's Day or February 15th is a holiday. So that's why we need some lead time. And because of shelter-in-place orders, the recorder's office is slow to process deeds. So I would rather have it sent in and registered mail and, hey, it was delivered, and make sure that, it was definitely signed before February 16th. But I don't want to do it right on February 16th. I want to have some leeway there. What can we do after? Before we get to questions, I'll just mention what can we do after February 16th? What are our options then? There's probably going to be a greater use of entities such as LLCs, limited liability companies. Remember I said at the beginning there are different rules for transfers of property held in an entity like an LLC or a partnership or a corporation. The parent-child rules never apply. So Prop 19 doesn't affect the entity rules. Unfortunately, it's not as simple as, oh, okay, we'll just form an LLC and plop the property in there and we're good. That doesn't work. The LLC rules we have two different rules depending on the situation. The first is if the parent already owns the property. They already own the property, they form an LLC, they transfer their existing property in the LLC. In that situation, the parent is considered an original co-owner of the property, and anytime cumulatively more than 50% of that ownership, of the original ownership of the LLC is transferred, there's a reassessment. So if dad takes a piece of property that he owns 100%, he forms an LLC, he transfers the property into that LLC, and then he dies and he passes his LLC on to his kids, that's more than 50% is being transferred, that's a reassessment. If dad already co-owns property with say 3 children or 2 children, and then they all form the LLC together, dad's only has 1/3. Upon his death, only 1/3 is transferred. We don't have a reassessment yet. So there's some way around it, but it's not perfect. Another scenario with LLCs is if you purchase the property from the very beginning through an LLC. So you, instead of buying the property and then forming the LLC and transferring into it, you form the LLC as an empty bucket and you purchase the property through the LLC. There, as long as nobody acquires more than 50% of the ownership, there's no reassessment. So if you had 3 children, for example, and so you acquire the property through the LLC and then you transfer the LLC to your 3 children, none of them have more than 50% at that time, and there won't be a reassessment. That's called the Dell maneuver, and that's named after Michael Dell, who's the computer guy. And in 2006, he bought a hotel in Santa Monica, and he implemented the Dell maneuver. The assessor didn't like it, and he appealed it, and he won in court. So there are limited scenarios, forming LLCs and dissolving them and forming others. That's going to have to be worked out, and that's going to be the new frontier. But it's important to understand unfortunately, it's not a simple situation. It's not, oh, I'm just going to form an LLC and put the property in there and we'll be all set. But that's all that we have left after Prop 19. One last thing before I start questions, I just want to go back here. I didn't address this, but the other consideration you have to think about, what if the law changes again? So you go through all this effort of rushing to transfer things before February 16th, 2021. We're under the old rules. We wouldn't have wanted to transfer it. We're gonna lose control. We hope this irrevocable trust will help us, but we know it's not the same as if we own the house ourselves. We're doing all of this stuff. Our kids are gonna lose the step up in basis and all this kind of stuff. And 2 years from now, there's another ballot measure that reverses Prop 19. I mean, it's possible. So we can only know and plan for the laws as they're written now. So I hope that was a good overview. I'm going to go ahead and open my chat box here and see what questions there are. So yeah, the question was there, that I addressed earlier. If the parents gift the property to the child, who pays the mortgage? Exactly. That's definitely an issue. First of all, make sure the lender's not going to call the loan. And then secondly, it would really be the responsibility of the child. So if the parent keeps paying it, there's some gifts there. What if both parents are alive and there is one child? Do each own 33%? There's an LLC. Well, it depends. So the issue is the issue is when you form the LLC, who are the owners of the LLC or who are the members? So when you create the initial documents, you can decide who the members are. When you transfer property into the LLC, though, if you don't want that transfer to be a reassessment, you need to make sure that the people who own the property before you put in the LLC have the same proportional interest as the LLC itself. So that can become an issue. So in other words, if mom and dad own the property 50-50 and they form an LLC where mom, dad, and child are 1/3 each owners of the LLC, but then mom and dad take their property that's 50-50 and they put it in there. Upon that transfer, they will be considered to have made a transfer of 1/3 to their child, and there would be a partial reassessment there. So it can get tricky in that situation. So again, you have to be careful. I mean, before February 16th, I mean, that could happen, right? You could, before, you could, if mom and dad own the property, they could transfer 1/3 to their child now under the current rules and then form an LLC. But the other problem too, though, is if you're transferring existing property, remember cumulatively when more than 50% of the original owners change hands, there could be an issue there. So death of first parent would be okay. Death of second parent would not, because death of second parent, we'd have a 2/3 change of ownership and there would be a full reassessment there. Two houses on the same property, you know, we don't, you know, if it's the same parcel, it's probably okay. But again, I would rather have some more guidance there to see that. So a lot of these things are not going to be answered. Any other questions? Okay, we got a couple more here. The properties are in a family trust. Yeah, so a trust, a family trust, I think what you mean by that is a revocable living trust that really has no bearing. If it's a revocable living trust, the owners of the trust still own the property because they're the lifetime beneficiaries. If it's a revocable trust, they still own it. You haven't transferred it at all. The transfer will take place when you die, typically. If by family trust you mean a bypass trust or a B trust, and there's some property already in there, the transfer has occurred to the surviving spouse, but the transfer to the child won't occur, the timing of it won't occur until the second parent passes away. And you know, who's the transferor at that point? Is it the first spouse that passed away or the second spouse? Should be the first spouse that passed away for the portion that's in that bypass trust. But again, how do we apply this $1 million cap on Prop 13? We really don't know. Yeah, the benefits of people over 55 who want to sell their home and move. So under current law, one time, if you're over 55, you can move your Prop 13 property tax base to another property if you want to move. Under current law, yeah, you can do it within the same county. You can't do it into another county with every county. Some counties will allow you to bring the property tax base in, and other counties won't. Under Prop 19, they've expanded those rules. So under Prop 19, you can, number one, you can do it 3 times in your lifetime. You still have to be 55, but you can do it 3 times instead of once, and you can go anywhere in the state. You don't have to stay in the same county. So that's one of the benefits under that. Are there other changes that protect not related to property transfers? Yes, there are. I mean, the other one is expanding the ability of someone who's 55 or older to transfer their property tax base to another home if they want to downsize, for example, or they want to move closer to their children. Again, under current law, you could do that once, and you weren't guaranteed to be able to leave the county under Prop 19, which actually for Prop 19 for the 55 and older, you got to wait until April before that becomes effective. So February 16th is not the date for that, but you can do it 3 times, and you can do it outside of the county. So if you're looking to move outside of the county and you're over 55 and you want to take your Prop 13 with you, wait until after April to be able to do that. Any other questions? Let's see.
Since we don't have any more questions, let's give Kyle a big hand. Thank you, Kyle.
Welcome.
Thank you, everyone, for attending. We've recorded this session, and it'll be available. You can view it on our Chamber YouTube channel. Thank you, Kyle. And now we'll be leaving the meeting.